Hello and welcome to our first edition of Employment Media. Today we're looking at the carry-on over carry-over. Employers will be happy to know that we may be one step closer to some answers over whether sick employees are entitled to carry over their holidays. The combined effect of the Stringer and Pereda decisions have meant that holidays can now be accrued when an employee is off sick. When the employee then returns to work, they're entitled to take these holidays, even if this means taking them in the next leave year. It is this point that is proving very difficult for employers. Our legislation, the Working Time Regulations, does not allow holidays to be carried over from one leave year to the next. This is leaving employers asking, how do they manage these decisions as well as the legal issues? Well, we now may be one step closer to clarification in this area. At the end of last year, a Leeds tribunal was the first to apply the Stringer and Pereda decisions in a UK context. To discuss this case further, the Shah versus First Yorkshire Limited, I'm joined by Val Dugan from our employment law team at Dundas Wilson. First of all, Val, can you tell us what happened in the Shah case?
Well, Mr. Shah had 4 weeks holiday pre-booked between February and March 2009, but he broke his ankle in January and was off work until April. Now, when he came back in April, he asked if he could reschedule that holiday and take it at a later date. His employers refused on the basis that their holiday leave year ended on the 31st of March, and in accordance with their policy, he couldn't carry over his holidays. Now, Mr. Shah objected to this because he had been off sick, and he raised a tribunal claim arguing that he should be entitled to take those holidays because he'd been unable to take them due to his sickness absence.
So why is this case so important?
Well, the Shah case is the first UK employment tribunal decision that actually says that private sector employees are entitled to carry over their holidays into the next holiday leave year. And it's also been very interesting to see how the UK employment tribunals apply European law where there is a conflict with domestic legislation. And I should also say that this was only an employment tribunal decision, and so it's not binding on other employment tribunals. But if this case is upheld on appeal, then that will set a precedent which other private sector employers are really going to be bound to follow.
Now, you specifically mentioned private sector employers. Is this different for public sector employers?
Yes, well, because of the way that European law operates, public sector employees are in a stronger legal position because they can rely directly on the European directive. And what's actually happened here is that most public sector employers have been following the Cabinet Office guidelines, which were published after the Pereda decision. And the guidelines actually say that holidays should be carried over into the next holiday leave year if the employee has been unable to take them because of sickness absence.
You mentioned the conflict with the UK legislation. How did the tribunal manage to deal with this issue?
Well, they took an interesting approach here, and they actually rewrote the regulations and added in a new paragraph to really make them say what they wanted. So they looked at the European cases and the UK legislation, agreed that there was a conflict, and then sort of came up with their own legislative drafting to plug the gap.
So what does all this mean for employers?
Well, at this stage, we're not sort of advocating that employers go out and alert their staff to the possibility that everyone's entitled to carry over their holidays, because the Employment Appeal Tribunal may take a different decision, and so it would be premature to make any changes to policy based on this case alone. Obviously, if an employer has refused a request and are now defending an employment tribunal application, then their prospects of success have probably reduced as a result of this decision. But, there's a difference between a litigation strategy and adopting a policy which affects the whole of the workforce. And employers are really going to want to implement any changes, in the most cost-effective way possible.
And what guidance would you give employers who are currently dealing with holiday requests?
I think really going forward, we're not going to get certainty here until we get an Employment Appeal Tribunal decision on the carryover point. or there is an amendment to the working time regulations. And since there's not even been a date set for the start of the consultation process, then I can't see that happening anytime soon. At the moment, what we are saying to employers is to deal with each request on a case-by-case basis until we do receive any further certainty in this area.
And that's it for our first edition of Employment Media, where we will be bringing you the latest in employment law news. Thanks for joining us.